Can the careless party's attorney subpoena all of your medical records? Hi, I'm Frank Nunes. I'm a California personal injury trial attorney practicing in the state of California. Join me as I answer that question for you. So many times people come into my office and we file a lawsuit against the person who is responsible, due to their carelessness, for my client's injuries. Well, true to form, we get back subpoenas and they are scorched earth. They want any and all records from any hospital, any doctor, any physical therapist, any acupuncturist, any medical facility that the client may have even driven past. Now, I'm being a little facetious there, but it is that broad. You should see the language in these subpoenas. But are the attorneys entitled to that much information? The answer is no. In California, your medical records are subject to your right to privacy. And the courts have held those subpoenas must be more narrowly prescribed than broadly prescribed to protect that right. Why? They don't want to discourage people from filing lawsuits for fear that their entire medical history is going to be laid out for everyone to see. So what do? You file a motion to quash, you call the attorney, work on narrowing the scope of the subpoenas. Many times it's successful. Sometimes the courts agree with you and they narrow the subpoenas for you. But then you have the final issue of what happens in reality. Practically speaking, the copy service shows up at your doctor's office. They hand a subpoena there. It could be narrowed to certain parts of your body, your leg, your ears, your arm. And what do? They just hand the whole chart to the copy service and they copy it. Well, we have a way to work with that too. We call the doctor's office ahead of time and let them know, hey, you're getting some subpoenas for our client, your patient. Please look at them carefully because they are narrowed to certain areas of that patient's body. And if you produce any of those records that do not relate to that, there's going to be a problem. So why am I telling you this? Because I see this happen all the time. People have information on the health records that's disclosed. It's not important to the case and it only causes embarrassment. Well, that's it for today's video on whether the careless party's attorney can subpoena all of your records. By the way, if you found this video useful, subscribe to our YouTube channel. Why? So you can continue to get great new content every time we post a great educational video. And if you have questions, I want you to call me since I can answer those questions. I answer questions like this all the time. You can reach me at 559-436-0850. I'm Frank Nunes, and thanks for watching.